welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with our Director of Litigation, Chance Weldon, as well as attorneys Nathan Seltzer and Clayton Calvin. We're bringing you Supreme Court cases as they drop this session, and today we're here to talk about a routine, easy case that came out of the Supreme Court on copyright law, Cox Communications. You guys are ready to talk about this, right? Right?
I'll be right back.
Yeah, sounds like
April
there was been a change of
We're here to talk
plans.
about Chiles v. Salazar, the case that dropped today. Which
So messed up.
is-
That was a real-time prank on air.
Right.
Yeah.
I gave Chance warning because I didn't want him to
I knew
panic
it was
on air.
coming.
He knew it was coming.
She didn't want the glare from across.
I didn't want the slight eye widening that means Chance is worried about what I'm about to say. No, we're here to talk about Chiles v. Salazar. This is a case that we've all been excitedly awaiting from the Supreme Court, and it dropped this morning. This is another kind of really quick to the punch podcast, so bear with us a little bit, y'all. We're trying to get the cleanest opinion out that we possibly can as we're bringing you our podcast today. Chance, you want to lay some groundwork for us? What is this case about?
Well, this case was really just about whether or not the First Amendment applies to conversion therapy. The state of Colorado had a law that restricted what therapists could talk about. It specifically restricted whether or not therapists could talk about helping people that, let me put it, minors who had asked specifically for help or guidance in controlling homosexual urges or gender dysphoria. The law prevented the therapist from talking about those things with them. They could affirm their gender identity, but they couldn't have any sort of conversation that did not affirm their gender identity. And the question before the court, the very narrow question, was simply, does the First Amendment apply with full force to that restriction in Colorado?
And as we're getting into this discussion, we'll talk about this a little bit more, but very quickly we get into some questions about scrutiny and some questions about licensure. So I just want to lay kind of as a factual matter, Ms. Chiles is a licensed practitioner, right? She is a licensed therapist by the state of Colorado. So she follows under this law not just because she's providing therapy or just talking to people in day-to-day practice, but because specifically she is a licensed practitioner.
And also, importantly, off the bat, just for context, it's a little bit different from like the cake shop case in that she actually offers it's totally dependent on the patient and what they want to do. It's not like she's just here with her own ideological priors and says, I want to help people deal with these issues in this way only. She actually offers services on either side of the kind of ideological divide, if you will, or
And-
so
Right.
she doesn't discriminate in any
And
way.
like Cake Shop, though, it's Colorado again.
Yes,
It is.
also a civil rights
also
statute out
You know,
of Colorado.
I don't speak for the entire state, but Colorado's been doing some stuff. But importantly here, we have a majority opinion written by Justice Gorsuch, and this is an 8-1 majority with a couple concurrences or a concurrence by Justice Kagan that clarifies some things. So let's jump into it. Let's start with the Gorsuch majority. Nathan, does Gorsuch say that this applies, that the First Amendment applies to this statute?
Well, he definitely says it applies. I think the question really, but the way that Chance framed it up is exactly right, because he said, the question is, does the First Amendment apply? If it does, then we have strict scrutiny, and if we don't, we have rational basis. Technically, you're still applying the First Amendment under rational basis review, but rational basis review is not really First Amendment review. It's really every law gets rational basis review, right? And so Gorsuch is saying absolutely, Justice Gorsuch is saying absolutely, the First Amendment applies, and here's why. And he walks through some of the basics of that. But he spends the majority of the opinion actually explaining why the exceptions that Colorado is trying to get into law, that what Colorado is basically saying is that, well, we're not regulating speech, we're regulating substandard medical care, which is like sanitation in a hospital or something like that, right? Like that would be the sort of thing. And then incidentally, we run into some speech concerns. Mm-hmm. But that's not...
Yeah,
go ahead. No, go ahead.
I think that brings us kind of to the primary issue on the front end of this is Colorado's argument. This isn't speech that we're regulating. This is conduct specifically that's being regulated here. Clayton, is this speech or is this conduct, and how do we know?
Well, if we're talking about Chiles, because this is an as-applied action.
And Chiles is the plaintiff.
Yeah, so Chiles is the plaintiff. This is the therapist, the licensed therapist in Colorado. The kind of therapy that she offers, and that is the basis of this suit, specifically is talk only. This is not other forms of therapy. This is not, there's a lot of Gorsuch talks about this a little bit, but this conjures images of like electroshock therapy, like physical therapy and stuff. That is a completely different suit. If there were anything physical related to it, it would be a very different answer. But this is talk only, talk therapy specifically, and that's why this case is unique.
I think it's like Colorado also makes that analogy. They're like, we ban all forms of conversion therapy, like in the law, including
which is
like
true. The statute is written
but it's
broadly.
Like electroshock and like probably the thing where they shove the ice pick up your nose and all the things. We ban all that stuff and talking about it, right? And it's like,
well, those
wait
are two different things. One of those is
that's
protected
not incidental.
by the Constitution.
One of these things is not like the other.
And it's worth stepping back for a moment to just think about, in the abstract, what we're talking about. The state here says you can talk about X, but you can't talk about Y.
Mm-hmm.
Of course, the First Amendment applies to that. Of course, the First Amendment, which says that when you restrict speech, it's going to trigger the protections of the First Amendment, like regardless of the context.
Right.
You can have a separate question about whether or not a particular restriction on speech might be constitutional in certain context. But that baseline inquiry of whether the First Amendment is even triggered, I think, is a straightforward inquiry that I'm glad the court got to the right, outcome on.
Yeah, and like talk about X but not Y is actually that's more getting to like the concurrence about that'll be a different question. In this case, is you can talk about X, but you can only say certain things about it. Is what Colorado's done here, which is really even more egregious.
Yeah.
There's an interesting quote from Justice Gorsuch on this exact subject. He says, in many applications, the state's law banning conversion therapy may address conduct such as adversive physical inventions, like we were saying, ice pick up the nose. But here, Ms. Chiles seeks to engage only in speech as applied to her, the law regulates what she may say. Her speech does not become conduct just because the state may call it that, nor does her speech become conduct just because it can be described as a treatment, a therapeutic modality, or anything else. The First Amendment is no word game. And then the majority points back to a couple of important cases from the 20th century, Cohen v. California and Holder v. Humanitarian Law Project, to say sometimes speech and conduct look really similar, but they are, in fact, two different things. So, Chance, can you talk a little bit about why it's so important to distinguish and to draw the line between speech and conduct?
Yeah, because really, when you're talking about speech is what's going to trigger the First Amendment protection. So almost all of the things when we talk about content neutral regulations or does this regulate viewpoint, all of those are tests or sort of factors that we look at to see is the government regulating conduct, which is not protected by the First Amendment. It may be protected by a different constitutional provision, but it's not protected by the First Amendment. Or are you regulating speech? And so the example that Justice Gorsuch gives in the majority opinion is, say, for example, there's an ordinance that prohibits unpermitted fires. It's just you can't have a fire in the park. And then someone is arrested for having a fire in the park, and the fire happens to be that they're burning a flag in protest. That's not going to implicate the First Amendment because the law itself just says no fires, regardless of the content of what you're doing.
It's not like you're going to have an exception,
right?
For, like if you're burning a flag, like, oh, it's not a fire anymore.
Exactly. It's still just a fire. You're regulating the the conduct of making a fire. But if, for example, it says no burning flags, now you're regulating based on the message that's being conveyed. And that's going to trigger First Amendment scrutiny because you're regulating content or message as opposed to just a bare regulation of actions.
You're letting fires go.
Yeah.
I think it's important probably at this point to step back a little bit and say from a procedural standpoint what's going on here. The question that's being asked is, does the First Amendment apply? But the question underlying the question is, what is the Supreme Court supposed to do if the First Amendment does apply here? So what the 10th Circuit had done was applied what we would call intermediate scrutiny to decide whether or not this was a constitutional rule. But because the First Amendment applied, strict scrutiny should have been the standard of review here. I think for those of you who didn't go to law school, there are kind of three different tiers of scrutiny, how a court looks at a statute or a regulation to decide whether or not it's constitutional. The most stringent one is strict scrutiny, which requires that the government show a compelling government interest that is and that the statute is narrowly tailored to meet that compelling government interest.
And this is for fundamental rights and
fundamental rights.
Suspect classes like
Right,
race
right.
and so on.
If you're
and so
looking at equal protection, whether it's a race claim under equal protection or like a First Amendment claim would trigger strict scrutiny. And we'll get in a minute.
And the government almost always, it's important about under strict scrutiny, the government almost, though not always, almost always loses.
Almost always
strict
loses.
in theory, fatal in practice. Or whatever.
Fatal in fact.
But especially in
Yes.
the First Amendment context, for strict scrutiny, it's pretty much fatal. Yeah.
Right.
court
So First
loves
Amendment
free
strict
speech,
scrutiny, the real question that's being asked is, or a question that's being asked is, does the government need to meet that high burden of strict scrutiny? The 10th Circuit applied an intermediate scrutiny, which asks
rational
the
basis.
question. Oh, you're right. I'm sorry. You're right.
That's what I thought.
There is an intermediate step, which is whether it's substantially related to an important government interest. And then
Yes.
there's rational basis, which actually flips the burden and says that the petitioner, the person who's approaching the government to say that the law is unconstitutional, has to prove that there is no rational relation of that statute or that regulation to a legitimate government interest.
Right.
So when Colorado looked at this law, Colorado said, okay, first of all, Ms. Chiles, you have to tell us that this has no rational relation to Colorado's interest, and in this case, Colorado's interest in protecting the children.
Yeah.
Generally speaking, protecting the children.
Predicated on the assumption that this is just a regulation of your professional conduct, and we're not going to consider this really to be speech.
And
Exactly.
Like that, the government does have a legitimate interest in like regulating the practice of medicine and protecting children. So it's like it's not about whether or not the government has that legitimate interest, and that's why the bar is so.
It's about whether it applies
low.
in a context where only speech is involved.
Yeah.
Right. So when we're asking the question, does the First Amendment apply here? In part, the question we're asking is, are we asking for a rational relationship between this regulation and what the statute actually does? Or are we looking for a compelling government interest and a narrow tailoring of this statute to meet that compelling government interest? In other words, we're asking the question, who has to prove it and by how much?
Yep.
And the answer to that question is, well, the 10th Circuit said rational relation. Supreme Court reversed and said, no, you have to meet this strict scrutiny burden.
Yep.
So when we're asking that question in this context, Chance, I think it's a little different than how we normally think of strict scrutiny because of the language of the First Amendment. Can you explain why the sort of those tiers that I just described don't really fit easily in this particular dynamic?
Well, I mean, I think there are a lot of originalists that would say that all of the tiers of scrutiny are just completely made up. I mean, we don't have tiers of scrutiny until a case called Caroline Products, footnote 4 in the 1930s, where the court decided that some rights get real scrutiny and other rights, even if they're in the Constitution, like property, for example, don't get meaningful review from courts. And then you have a whole, 3 generations at this point of doctrine built up around that. Different types of scrutiny, intermediate scrutiny, what gets what kind of scrutiny, multi-layer test,
So many factors.
So many balancing tests. And,
Which don't worry, we're not going to get into.
We're not going to get into any of that.
Didn't start until 150 years after the country started.
Until after the Constitution had been ratified. And some justices like Justice Thomas have pointed out the fact that all of that's made up.
When you say made up by justices?
By
over
judges
the years?
on the Supreme Court, mostly dating back to Caroline Products in a footnote is actually what gives you the birth of tiers of scrutiny.
Do you know who was the court at that point in time?
Oh, it's a post-New Deal court. This is, I believe, post-switch in time to save 9.
Okay.
So this is
I'm trying to remember who wrote that.
Who wrote Caroline Products? I can't off the top of my head.
Pop quiz.
And so back to the question, though, you said the First Amendment doesn't have any of that.
Right.
It says
Right.
Congress shall make no law. It's a jurisdictional limitation on government power. That's been incorporated against the states through the 14th Amendment, either through the Privileges or Immunities Clause or through the Due Process Clause.
Meaning that Congress shall make no law, and also the states shall make no law.
Right.
Abridging the freedom of speech. And so that's a jurisdictional limitation on government power, full stop. So the question really becomes, from an originalist perspective, is this a restriction on speech, as that would have been understood at the time of ratification? I mean, that's going to do most of the work for you without having to decide whether what they're regulating is important or whether it's tailored or any number of other things.
So I think it's an important kind of framework here, because if we're taking that truly originalist, frankly textualist perspective of the words in the Constitution mean exactly what they say, it's Congress shall make no law.
Yeah.
But if we're taking this, honestly, what is in the majority opinion here, that the tiers of scrutiny apply, the question isn't shall Congress make no law, it's does Congress have a good enough reason for making a law? And does this law satisfy that reason? And that frankly runs afoul with the Constitution.
I mean, this is why some
have said if we take that position,
right? Because it's not really the words themselves don't lend themselves to like a second look at the legitimacy of the interest involved. That judges get to sort of like second guess the legislature. They just say, is it speech or not? If it is, you shall make no law.
And it's important to remember that that's actually the exact opposite of what was happening in Parliament at the time of the American founding. So Parliament actually, the English Bill of Rights was unless Parliament deems it in the public interest for all of your rights. All of your rights were contingent on whether or not the legislature had a good reason. And the founding fathers rejected that. So to like read that back into the Constitution the way that we've done with tiers of scrutiny is sort of a weird thing to do from an originalist perspective. In fact, to get a little nerdy on it on the fly, like when you read cases like Van Horns-Lacey versus Dorrance, that's what the Supreme Court, and this is in the 1790s, by the way, says the primary difference in American constitutions and the English Bill of Rights is that our rights aren't contingent on the public interest. We have rights that are jurisdictional limitations on government power. And so to read those things back into the Constitution is not necessarily an originalist way of doing First Amendment law. However, that's the First Amendment that we have right now, and this case is just about whether the First Amendment applies.
Right. That's not even the question that's before the court at this point. The question that's before the court is quite simply, does the First Amendment apply here? Because if it does, at a bare minimum, you're going to have to show strict scrutiny, and the 10th Circuit hadn't done that.
And in practice, that often ends up being a jurisdictional limitation, because most things, not all things, but most things do not satisfy strict scrutiny.
So eventually, if this comes back on remand, so it's been sent back down to the 10th Circuit. The 10th Circuit redoes their analysis and says, yep, we think that Colorado's interest in protecting the children is good enough to satisfy strict scrutiny. We could see this back up at the Supreme Court again.
Yeah.
Right. As a function of this other analytical method, the tiers versus the jurisdictional bar.
Right. Let's talk just briefly about sort of this viewpoint discrimination, content discrimination issue that kind of underlies this. Justice Gorsuch explains the distinction here a little bit and says, for a gay client, Ms. Chiles may express acceptance, support, and understanding for the facilitation of identity exploration, which is a quote from the statute. For a client undergoing gender transition, Ms. Chiles may likewise offer words of assistance. But if a gay or transgender client seeks her counsel in the hope of changing his sexual orientation or gender identity, Ms. Chiles cannot provide it. The law prevents her from saying anything that attempts to change a client's sexual orientation or gender identity, including anything that might represent an effort to change her client's behaviors or gender expressions or romantic attractions. So there's this line in the sand that Justice Gorsuch draws and says, this is viewpoint discrimination because there are certain things that she is not allowed to say. Not necessarily certain positions like we normally think of in viewpoint discrimination, but certain things she's not allowed to say. And by prohibiting her from saying those specific things, we've created viewpoint discrimination. Clayton, is it a helpful distinction to look at viewpoint discrimination and content-based discrimination versus non-content-based discrimination as we're analyzing this problem?
I think it can be. I mean, as I remember, they both face the same level of scrutiny, though, right? I mean, they both face strict scrutiny. But yeah, I mean, and the concurrence here, Kagan's concurrence talks a lot about that, which I guess we can get into later. But yeah, I think it's helpful.
I think the substandard care part of it is where the state is trying to rope in and turn talking to people into practicing medicine. And as Justice Gorsuch notes, that had never even been done before the 1970s. So practicing medicine, going back, it makes sense that the practice of medicine would be regulated because you want to make sure that some guy that's about to cut someone open and move things around has had some level of training in that before they start doing that. And so the state obviously has an interest in making sure and licensing and regulating, okay, this person has been trained and can do this person hasn't. But talking doesn't have the same risks that surgery has. And so when you have like this, you're talking about this certain thing, and if you talk about it wrong, that's substandard care. That's very much different from if you haven't cleaned the patient, like haven't wiped down the patient with antiseptic before opening the patient up, that's substandard care. That because the patient is not harmed by talking. At least traditionally, we don't view talking as harm, and so the state doesn't have the same interest. And I think that's what Justice Gorsuch is really getting at here is this isn't incidental, and we can maybe talk about what the incidental regulation of speech is, but this isn't incidental regulation of speech. This is regulating speech as speech, and we can't have that under the First Amendment.
I think there's an important point that you just made, that the speech itself is what we're discussing in this context, and it's not just we're preventing harm in the we're cutting into someone's sense.
Right.
I think that's probably where Justice Jackson disagrees most strongly with the majority, and we'll come back to her opinion in a moment. She would say that there's really functionally no difference between an untrained person chopping into you and a psychiatrist telling you words that ultimately will have a serious impact on your mental health.
So they're in a position of authority. You're there. You're trusting them. You're gonna make decisions based on what they say.
And she actually references in one of her footnotes, talks about this horrible, tragic story of a child that received bad therapy.
Right.
and
which can happen. It's not an unfounded fear.
Right. It's not an unfounded fear. However, the First Amendment doesn't have an exception for that. There's not a harmfulness exception to the First Amendment. But we do have some kind of limitations on the First Amendment in that respect.
And if that were to happen, importantly, a therapist who really did give like a misrepresentation or some sort of who committed malpractice, in other words, and was like, oh, like I think we were giving the example, if your toe hurts, looks like you're probably going to have to saw off your leg. I mean, that's more of physical conduct kind of thing, but an emotional analog to that. They might be able to be liable for malpractice.
I think like recommending suicide is like an example that comes up.
Whatever it is, recommending, you should pack up, you should leave your family, you should move across the country, never talk to him again, and then that harms the person's life is bad advice. I don't know if that would get them into malpractice zone, but anyway, this opinion does not change the fact that a therapist can still be liable for malpractice based on things that they said in certain circumstances. Right. This is just saying, hey, a legislature is not allowed to preemptively decree and impose this restriction as a prophylactic upon uniquely on speech itself.
Without triggering First Amendment scrutiny. It's even a step removed from that. It's like if they do, it's not even answering the question of whether that sort of restriction would be permissible.
Right.
The only question before the court is like, does the First Amendment have anything to say about it? Mm-hmm. I think that's the thing that Justice Jackson, what's the difference between, cutting someone open or talking about something? Well, from the court's perspective, the difference is one of them involves the First Amendment, right? And those are different things. Like we treat these things sometimes as if they're just policy debates that the court's trying to adjudicate. But for a judge, what's the difference practically speaking? It's like, well, no, there's a law involved, and that law is the First Amendment. And the big difference is talking is protected by the First Amendment, cutting bodies open isn't, right? And that sort of distinction should matter.
Which brings us to, we'll come back to Justice Jackson's dissent. Let's take a quick little pit stop at Justice Kagan's concurrence, because she draws attention to something within the context of the majority opinion that asks some different questions. So she says this is viewpoint discrimination, and viewpoint discrimination always falls under the First Amendment. Yeah. Were this not viewpoint discrimination, it's a harder question. She doesn't actually go so far as to say that this exact or a similar statute that isn't viewpoint discrimination based doesn't trigger First Amendment protection, but she says it's a harder question. Chance, what are your opinions on that?
Yeah, I think what she's getting at there is there are going to be some line drawing problems. So, for example, if you're going to license the speaking professions, which again is something that we really don't have happen until the 1970s with most speaking professions, there's got to be like a scope of practice sort of restriction that you would ordinarily think of, right? So if you think about someone who's, say, licensed to give instruction in something, if they're licensed to give instruction in math, and then they start teaching Russian history, right? That's outside of their scope of practice. And so the question would be, well, maybe that's a tougher case, like how you draw those scope of practice limitations. The lines get fuzzy. And she says that's a tougher question about how the First Amendment's implicated, at least for her.
If the law had said talk therapists are not supposed to talk about astrology in relation to the person's therapy,
right?
That would be a different case. She's not saying how it would come out, but it would be a different case, which is legitimate for a judge to sort of rule conservatively on the narrow facts
right.
before
The
that.
facts in front of us are this particular Colorado law, and this particular Colorado law very clearly viewpoint discrimination.
I mean, it's something that like Justice Roberts has done in a bunch of cases. Justice Roberts loves to say, if it's not necessary to decide more, it's necessary to not decide more. And that's a very sort of Roberts-esque.
Judges do that all the time,
But she couldn't even do counseling in Colorado if she wasn't licensed.
Yeah.
So that makes it different from, for example, teaching,
Yeah.
where like you're licensed to teach one subject, but if you wanted on the side, if you wanted to go teach Russian history and you're a math teacher, like no one's going to prohibit you from doing that and put you in jail or fine you or anything like that. But in this case, she can't. She can't do any counseling if she's not licensed.
Yeah.
It also kind of begs an interesting question of if that licensure is an acknowledgement that you are free to do a certain activity, can that licensure be contingent on you not doing certain things that might be contained within that activity? In other words, if I am licensed to practice medicine, can I then be prohibited from discussing astrology with my patients while they're in the office with me?
I feel like that's the opening line from the dissent. It's like directly addressing
and
that.
this is, I think, I'm just asking questions. I'm just asking this question because it's curious, not because there's an answer to it. I don't think that Kagan's opinion actually gives us an answer. She just says it's a harder question.
Yeah. It's a thought-provoking case, certainly.
Yeah. So let's move on to Justice Jackson and her dissent. I think it's almost half of this opinion is justice, or this.
Yeah, she wrote the longest opinion.
In pages, she wrote the vast majority. She comes right off the bat swinging. She says, there is no right to practice medicine which is not subordinate to the police power of the states. Nathan, what do you think about that?
And she goes on to say this was true 100 years ago and it should be true today. And I actually, if we were just looking at that quote in a vacuum, I would be like, absolutely, that's true. That because we're talking about the right to practice medicine, but you don't have the right to do it if you haven't been trained and things like that. So there's the police power that she's referring to here. I think we need to talk about what that is, because I think that where I would disagree with Justice Jackson is what her concept of the police power actually is. And
or does it apply here?
No. I think it applies, but it's rooted in harm.
Right.
So it's if in the practice of medicine, if I could harm someone by doing something that they can regulate I'm not authorized to do surgery, like open heart surgery, if I'm blind, things like that, those are reasonable. And the police power is what enables the state to come in and say, you can't do that, you're going to hurt somebody.
Yeah, health and safety basis, common law, like common law forms of harm, not necessarily like esoteric, like psychological harm, but just like
Chance is chomping at the bit.
Yeah, Chance. Let me just ask a very pointed question, which I think will help kind of frame this discussion. When we as originalists talk about police power, what are we talking about?
The regulation of health and safety, traditional common law nuisance restrictions, things like that. As the court put it right around the time that the 14th Amendment was ratified, it's based in the maxim secutare, right? This idea that you can't use your rights to harm others. It's morphed into something that it's like whatever the legislature wants to do or whatever it thinks is there's a good idea for is now the police power. But the folks who ratified the Constitution, the folks who ratified the 14th Amendment would have thought that the police power was actually a limited thing. In this case, there's a separate question, though, too, because not only does she not define the scope of the police power, where we may disagree with Justice Jackson, but she also uses the word medicine, which would have been different in 1926. Yeah. Again, talking to people wasn't considered the practice of medicine until I think Gorsuch says 76.
Yeah.
until 50 years after that opinion.
Medicine would have been all about physical contact, taking something.
Yeah, and the earliest regulation of doctors was based on this idea that you don't really have an innate right to start cutting on someone else's body. Like when you're starting to manipulate someone else's body, then the state has an interest in making sure that's done properly and safely.
And giving drugs.
Things like that. Things that actually interfere with the functioning of the body.
And part of that reason is that like a drug could be a poison for one person and an antidote for another person. And so, and not everyone knows the difference. So we need those things. And so, yeah, absolutely. So I would agree with, to get back to your initial question, I would agree with her statement that there's no right to practice medicine, which is not subordinate to the police power of the states. But what the police power actually is, I think is far more limited than sort of this idea that the police power is anything the state anything that's a law is the police power, and that's just, or anything that's enacted by a legislature is a police power, and that's just not the case.
And anything that you want to call the practice of medicine is the practice of medicine, even if it is just speech.
Right, you can't just label something medicine and then it becomes medicine. Because then if you can just change labels and then the First Amendment does or does not apply,
and speech isn't speech anymore. Right.
Suddenly none of our amendments apply. We can say that's not a gun, any of our amendments just go away under that labeling
system. That is
system.
commerce. So.
Yeah. She's showing a level of deference to the states, which is it's kind of this two-step deference to the states, because she says the state, we should show deference to the states. The states have police power, and also at the same time, the states are showing their deference to the experts in the arena, which really smacks of early 20th century kind of, again, the Stitch in Time and New Deal jurisprudence that looked at the experts and said, well, who are we? We're just judges. Who are we to decide what is best for the residents of the state of Colorado? Mm-hmm. And as she's going through this and making this analysis, this deference kind of rings through on multiple occasions. But is there some righteousness, I suppose, to this claim? Like Nathan was just saying that medicine is something that can be regulated by the states. Mm-hmm. Is there some righteousness to Jackson's observation here?
Yeah. I mean, I think let's put it this way, I think she really is convicted by a sincere belief that that talk therapy around these specific issues that are very personal and can really affect the person very deeply, can produce harms. And so, like, if somebody's given the wrong advice about these issues, they can go harm themselves, or it's just like she's pointing out all the evidence that like these really, lead to negative results in some situations, harmful results. And because of that, the state should be able to she's assuming that the state should be able to regulate that. And I think she's probably she's obviously sincere about that, and we can see where she's coming from. But again, the issue is this speech?
Yeah.
Because if it is, it's protected.
But on the deference point, she would advocate that we defer to the legislature here because they know best.
But we can't defer to the legislature with respect to whether something is speach, because that's
100%
taken out of the jurisdiction.
100% agree with you.
Okay.
I want to articulate, though, her viewpoint is that the legislature, the licensing board here, that they are the experts and they know what the standard of care is, or what it should be. And I guess she would also say that the legislature can set the standard of care to whatever it wants and encompass anything within that it wants, which is a very broad conception of the police power. And I think Justice Gorsuch really effectively addresses this by saying, he says, the line is, so what if the kind of reflexive deference to currently prevailing professional views may not always end well? See Buck v. Bell, which he's referencing. By the way, Buck v. Bell came out 1 year after the opinion that
the quote
Lambert.
that I just read, was
that
1 year
that
before.
Jackson opens her.
Yes.
So let me give some background on Buck v. Bell before we wander too far astray. Carrie Buck was a woman who was deemed to be I don't remember the exact term. Incompetent.
In the 1920s.
Yes, in the 1920s, a group of doctors went to the Virginia legislature and said, this woman is incompetent. She can't take care of herself. She can't take care of the children that she has. we would like to forcibly sterilize her. And that was permitted by the Virginia legislature. And the question went up to the Supreme Court because Ms. Buck did not want to be sterilized. And the Supreme Court said, nope, that's fine. She got her due process. She can be sterilized because the experts say that it's okay. And she got her day in court. And that's the end of that. And so she was, in fact, sterilized. And it's kind of a blot on American jurisprudence that Buck v. Bell exists in a backhand that's frequently used by the justices. What's the application of that here?
I just want to put an exclamation point on Buck v. Bell. Like, in the majority opinion, upholding this law,
This is the quote.
Justice Oliver Wendell Holmes says 3 generations of imbeciles is enough.
Yeah.
Okay, so that is judicial deference to a statute. And that, I think most people, even Justice Jackson, I'm sure now, would say that was wrong. But when we just reflexively defer to a legislature and what they think is best, then you can get a Buck v. Bell situation. Whereas we say, no, actually, even if the legislature wants to do this, the First Amendment still applies, which you rightly brought up. It doesn't matter what the legislature thinks is best or how expert they are or how correct they might be. Ultimately, they just can't do it.
The reason we have an independent judiciary is specifically so they do not have to defer. They're not supposed to defer.
And can we point out a little bit? I think it's worth bringing up maybe Justice Jackson's selective deference, because she rejected this exact same argument about deference and scope of medical practice in Scrutiny.
Which case was Scrutiny?
Scrutiny involved Tennessee regulating transition surgeries for minors. So in that case, they said that was outside the scope of medical practice to do gender transition on minors in that case.
And it was the other side. They were basically taking the opposite stance from Colorado. Go
and
ahead.
so the state of Tennessee had said that we're not going to allow gender transition therapies for minors in the state of Tennessee in most circumstances. And she dissented from when that was upheld. She was like, no, we don't give deference to the legislature here. And so sometimes she's almost uniformly deference, but there are limits to the scope of what Justice Jackson believes deference is appropriate for.
I think to an extent she probably has a perception in her own mind of what experts and therefore what states who are listening to those experts are worthy of deference. Because she's a human. We all think that way. We have all decided which experts we're going to listen to. And she probably has said in her own mind, these are the ones that are right and these are the ones that are wrong. And I will give deference to the states that are listening to the ones that I think are right.
And in
whether
fairness, you
or
do
not
have
we
to do
intend to do that.
If you do have to do some sort of attempt at objective judgment, like certain things are true, these are actually harmful, certain things are not. So it's, in fairness, people do that, but it's about tethering it to the text and the structure of the Constitution.
Yeah, but we don't get to decide what speech is good and what speech is
when
bad.
It comes to
because
speech,
the speech part is the relevant thing.
Yeah.
Right.
Which is what's important here is that the question isn't, again, the question is, does the First Amendment apply? The question isn't, does the state think that the First Amendment should apply? That's not the question. The First Amendment doesn't have an exception for when states have talked to their experts and decided that this is what's best, that this First Amendment is Congress shall make no law. So we end up in this kind of era of thought with Buck v. Bell and a charge from Justice Gorsuch to Justice Jackson that, hey, your line of reasoning leads to a place where a state can forcibly sterilize a woman against her will. Clayton, what is Justice Jackson's response to that charge?
I'm trying to find her specific words here in a footnote. I don't have Control F with me, but she...
You didn't bring Control F in your fingers today, Clayton?
I keep forgetting I can't do that with my fingers. I don't know, in my own personal opinion, if I may, it didn't seem like she responded to that in a very direct way. She just kind of said, yes, Buck v. Bell was a shameful decision. I think that's the word she uses. But just because that was a shameful decision doesn't mean legislatures' ideas of what the standard of care is don't evolve, and because we can take it for granted and accept the fact that they do evolve, and the arc of history bends towards justice seems to be sort of the underlying assumption. That it's actually safe and it's okay to defer to legislatures because she kind of suggests they're more often going to be right, at least in the modern era.
I think it's
than
almost
not,
like,
but so I don't find a lot of principle in that response. It's kind of like a factual assessment that isn't entirely clear.
Yeah.
As to the why.
it's almost like she's like saying they'll be right eventually.
Yeah. And that can't be a reason for
Ooh.
But
us
yeah.
to
but that's also like when we say,
not intervene.
you know, the state could also like change a law to like stop violating your constitutional rights. But we don't say just because the state could change the law and it may eventually be right down the line at some point that we just defer to the state in this case. We have to look at what they're doing right now and if that comports with the Constitution. That's all the majority's doing. When it comes back up, I think her line of reasoning might have more force when we're actually weighing, like, does the state have a compelling interest?
Yeah. If it's not speech or as much or
Right. Like, say it comes back and they apply strict scrutiny, and then they're hearing the case, then this idea that the legislature has reasons for doing it and the standard of care, and she could get into that a little bit more.
Yeah, it'd be more
and it might
appropriate.
have more force. But she's saying in this dissent is saying
In this
we don't
posture.
need to apply the First Amendment at all.
Yeah, and this is also, just for the record, an 8-1 opinion. She is holding to her convictions and writing alone.
And that's sort of like a weird place to be if you think about it. There's a line from one of Justice Willett's opinions, and it says, you know, the thing of judging is sometimes you have to judge, hence the title.
Yeah.
It's like the whole reason that we have a judiciary at some point is to look at the jurisdiction of the legislature to do certain things, or the jurisdiction of the executive to do certain things, like going through the who decides kind of approach and saying, like, what does the Constitution say and what does the Constitution limit is a judicial function. If we just roll over to if the court just rolls over to the legislature all the time, then it's not actually performing its constitutionally mandated function.
Right.
You know, as the court pointed out in Van Horn-Sleesey, again, they're a separate and co-equal branch of government.
And so long as they're doing the judicial function,
Yeah.
deference is not appropriate. There are plenty of people who would say, well, we don't want to wade into, if it's a legislative function, like a policy decision, then the court should stand back because that's
Yeah.
not their role.
Yeah.
But if it's a constitutional, jurisdictional, judicial decision, then it is.
But here the court is not saying we think this is a bad policy in Colorado.
Yeah.
We
Right.
disagree.
Right.
They're saying
That
that,
would
this
be
is
inappropriate.
speech. That's
Yes.
what they're saying.
And actually, I saw an interesting headline from Vox before we walked down here saying, sadly, this opinion is correct. This is even those who would disagree on a policy standpoint, from a policy standpoint, disagree with the outcome here. From a constitutional standpoint, this opinion is correct. And I think the fact that 8 judges are standing together with their arms locked, because even the 2 liberals that have their own concurrence are not concurring for different reasons. They're emphasizing the reason that they did concur, but the simple answer here is yes,
And
the First Amendment applies to this conduct.
And the concurrence is, it was Kagan and Sotomayor in the concurrence, and she makes a fine point of that. Kagan does a good job of saying, sort of suggesting that, hey, if the shoe were on the other foot, and let's say Tennessee or Texas or something made a law where, you were prevented from affirming the orientation of the person.
Yep.
But you had to, you know what I'm trying to say. If the shoe were on the other foot, then that would equally be viewpoint discrimination, and it would violate the First Amendment also. So.
And
I wonder
if that exact question was in front of the court, if the exact opposite statute had been enacted, if Justice Jackson would still have been dissenting. I don't know. I think that's a question that probably won't be answered anytime soon. Any final thoughts? Any concluding thoughts on this particular opinion? Where do we go from here?
I want to just I kind of want to mention Justice Jackson does what Colorado does in their statute, and I don't think it's right to equate talking about gender affirming care or whether or not you have supported to actual things like conversion therapy. Like, they use that language very intentionally, Colorado did, because they wanted to invoke like people getting like the electrodes on their head and stuff like that.
Right.
And that's not really what the law was doing, and that's not what it was aimed at. And so to pretend that is happening, I think what it does is it unnecessarily politicizes and brings up these sort of gruesome visuals that don't have any place in a discussion about speech.
Yeah.
Well,
because to be clear, I mean that type of physical harm, that type of therapy would be, the state could ban that.
But I guarantee you, there's some headline out there now, like Supreme Court authorizes conversion therapy or something like that with 8 and that's not what happened.
And this is one of those things about, I think, in the long run, people on the front end, they like to say like, oh, the big cases, they're heavily divided, and this is, this was a big case when it was argued. Now it's dropped 8-1 because at the end of the day, the case wasn't about the policy of conversion therapy or anything else. It really does come down to, when the state says you can't talk about stuff, does the First Amendment have anything to say about that? And yeah, that's an easy question. It should be an easy question, and that's why it was 8-1. And it'll be interesting to see how that disappears from the consciousness, where it would have been a big case, but then it's just so obvious on the back end, and it doesn't fit the narrative that the media would want to have about it. It might just disappear on the back end.
Yeah, this is not a watershed case. This is not changing First Amendment law. This is not,
This is just applying it to sort of
this is a rote application of First Amendment jurisprudence, which is fascinating in how high profile it is, walking that same kind of steady, narrow line.
Colorado be crazy sometime.
Okay.
We love Colorado. How dare you.
That brings us to the end of today's docket. If you have enjoyed our conversation today, please leave us a review and join us next time for more Rightly Decided.